Irretrievable breakdown of marriage. The ground of irretrievable breakdown of marriage is actually not provided in the Hindu Marriage Act, yet one can avail this ground of divorce. Confused? Don't worry, we're here to help you. Definition. A collective definition of irretrievable breakdown of marriage can be culled from the 71st Law Commission report and also from the 217th Law Commission report as such failure in matrimonial relationship or such adverse circumstance to the relationship that no reasonable probability remains for spouses living together again as husband and wife. In other words, the relationship is broken beyond repair. Irretrievable breakdown of marriage can be another ground for divorce. Even though the ground is not provided in the Hindu Marriage Act of 1955 officially. How does that work? Even though the ground does not formally exist in the statute, the court often grants divorce on this ground when it is clear that any further legal proceedings will only lead to a long-drawn, caustic legal battle with corresponding no benefit to the relationship. Who can grant divorce on the grounds of irretrievable breakdown of marriage? The opportunity to grant divorce on the grounds of irretrievable breakdown of marriage is available only with the Supreme Court of India under Article 142 of the Constitution of India, which provides that any appropriate order may be passed to do complete justice in any case, and complete justice is the key word. This has been held by the Honorable Supreme Court itself in the case of Anil Kumar Jain versus Maya Jain, and also in the case of Manish Goyal versus Rohini Goyal, which are 2009 and 2010 judgments respectively. So no other court can grant divorce on the ground of irretrievable breakdown of marriage except for Supreme Court of India under Article 142 of the Constitution. However, many believe that Section 13, Clause 1, capital A of the Hindu Marriage Act, added in 1964, is a small step in the direction of the ground of irretrievable breakdown of marriage, though the ground officially does not exist. Judgments on the ground of irretrievable breakdown of marriage. The Supreme Court has refused to grant divorce on the grounds of irretrievable breakdown of marriage in many a case. For example, in Savitri Pandey versus Premchand Pandey, which was a 2002 judgment, the Supreme Court held that no circumstance exists for the exercise of power under 142 of the Constitution. The Supreme Court has also granted divorce in many cases on the grounds of irretrievable breakdown of marriage. Example, in Samar Ghosh versus Jaya Ghosh, which is a 2007 judgment. The Supreme Court held that the parties had been living separately since 1990 and the decision was of 2007. And they further held that there is no emotion or feeling left between the parties and the marriage is irretrievably broken down. So there's no reason to cling on to it and it's better to grant divorce. But the most important landmark judgment on irretrievable breakdown of marriage is the case of Neelu Kohli versus Naveen Kohli, delivered on 21st March 2006 by a 3-judge bench, and the judgment was written by Honorable Justice Dalveer Bhandari. In this case, the parties were married in 1975 and had 3 sons, for whom they established 3 factories. The husband alleged that due to the ill-temper and rude behavior of the wife, he cannot continue with the marriage, and he moved out of the house in 1994 and started living separately in a rented accommodation. After that, there were multiple FIRs lodged between the parties and many civil and criminal proceedings. Finally, the matter reached Supreme Court of India, and after much consideration, the Supreme Court in Para 17 held that even at this stage, the respondent does not want divorce by mutual consent. From the analysis and evaluation of the entire evidence, it is clear that the respondent has resolved to live in agony only to make life miserable hell for the appellant as well. A marriage between parties is only in the name. To keep the sham is obviously conducive to immorality and potentially more prejudicial to the public interest than a dissolution of marriage bond. Hence, the Supreme Court of India granted divorce on the grounds of irretrievable breakdown of marriage holding that there was nothing left in the marriage, and to continue to hold on to it would be a sham and would be counterproductive. There have been many recommendations to add the ground of irretrievable breakdown of marriage in the statute book officially. However, no work has still been done on it. Criticism. The granting of divorce on the grounds of irretrievable breakdown of marriage has been criticized by many, including Justice Markandeya Kaju in the case of Vishnu Dutt Sharma vs. Manju Sharma, which was a 2009 judgment delivered by a two-judge bench. Justice Kaju criticized the fact that the court was granting divorce on a ground not existing in the statute, and hence effectively taking over the work of making laws. However, since the Neelu Kohli judgment was by a bigger bench of 3 judges and not like the 2-judge bench of Vishnu Dutt Sharma, the Neelu Kohli judgment still continues to hold good. Revision of all that we've learned today. We learned the definition of irretrievable breakdown of marriage as provided in the Law Commission reports. Then we learned who can grant divorce on irretrievable breakdown of marriage, that is which court. Then we learned the judgments in which the divorce was granted on the grounds of irretrievable breakdown of marriage. And finally, the judgment criticizing the ground of irretrievable breakdown of marriage and granting of divorce on it. If you want more of our videos, please subscribe to our channel for future videos. Thank you.